because for at least for the entertainment industry, for the content creators of the world, because when you put anything online, whether it is audio, whether it's video, whether it's a photograph, the images and so on and so forth, there is copyright there. And of course, under our copyright law, as all of you know, that registration is not mandatory. You don't have to get your registration done with the registrar's office. So it makes a little matter a little more complex, especially I think for Paytm. How do you do it? Because as you also know, it's an interesting fact that for a photograph, the copyright owner is not the one whose photograph it is, but of course the one who clicks it. So the guy here who is actually taking a video of mine is the copyright owner of whatever I'm saying, and not myself. So that also becomes a complex situation. And as far as artists in the country are concerned, yes, their particular sung song or their performed song gets put onto the online platform. It's definitely a great way for the artist in the digital world, because get you instant fame, it gets you instant money, but at the same time, you do not have control over it. You do not know who is doing that. And if you go on YouTube, there are many people who are putting up the videos of artists and of films, but they are making the money and not actually the copyright owner. So that's again a very, very challenging situation as far as online exploitation is concerned, and that's where the intermediary liabilities come into the picture. And therefore, I would now turn my attention to Lakshmi Devi here, because she's from Surana and Surana, and she would sort of rather be in a better position, because it's a big law firm, to tell us more about into the online exploitation of content and the intermediary liabilities thereon. Lakshmi.
Thank you, Sanjay ji, and glad to be part of this forum, power-packed by women with diverse, deep, and intelligent perspectives. Sanjay ji has been very instrumental around 5 months back in inking of some agreements which post the Bombay High Court decision in a couple of matters, gave musicians the right to claim royalties, as he mentioned. Which brings us to one of the tales that some of you may be knowing, from the Jataka tales. There is a story of a very poor man who used to live in a small hut. So, poor man, small hut, there is a pest problem. He had rats running all over the hut. And he killed one of the rats, and the dead rat was lying there. He was thinking of how to kill the other rats. At that point of time, what he did is he killed the rat and flung it out onto the path in front of his hut. So at that time, the king's chief advisor was passing in front of the hut, and king's chief advisor, there would be 10 to 20 people along with him. One of them said, careful, don't stamp, look, there's a dead rat, just pass around it. So the king's chief advisor did pass around the dead rat. He also looked at the rat and he said, an intelligent person can make money even from this dead rat. So the man sitting in the hut thought, okay, it's a dead rat, I know that. He was of absolutely no use to me. He was a pest, so I killed him and threw him out. But the king's chief advisor is telling this, and king's chief advisor would not say something like this just like that. There must be something to it. What he did is he took up that dead rat and put it in a cage. Then he thought, okay, dead rat he's saying is of such value, so maybe all the live rat running around my hut must be of even greater value. He managed to catch all of them, put them in a separate cage, and he thought, okay, let me see if somebody buys this. He went and sat in front of his hut, nobody bought it, then he shifted venue and location, went and sat where there were a couple of big houses. Finally, a person came out from one of the houses and said, will you sell me your rats? The man was surprised. He did not know that there would be takers for his goods. He said, yeah, sure, I'll sell it to you. What do you want me to sell it for? He said, I'll take all the live rats for 10 rupees each. He said, fine, yeah, I'll sell it to you. I have 20 live rats. I'll sell each rat to you for 10 rupees. And then he said, and the dead rat is also for sale. Oh, the man was like, you want to buy the dead rat? And the buyer said, yeah, of course I want to buy the dead rat. I mean, look at it, it's ready-made food. The other things, I have a cat, so this is for him. The cat has to run around and kill the other rats and eat them. This is like ready-made food, he can just have it. So please sell it to me. He said, okay, how much will you pay for it? Live rats are 10, I'll pay 20 to you for this. And the man was so happy, he sold the dead rat also. With that initial corpus, the Jataka tale goes that he set up several small businesses and ultimately he became a successful businessman. Now, why this story now? Singers' rights were not clearly defined under the Indian Copyright Act. As per section 18 and 19, performers did not clearly include singers. Then after the Copyright Amendment Act of 2012, section 39A was introduced, whereby the concept of moral rights and royalty to singers being part of performers came into the ambit of the intellectual property protection that was available for performers. Now, there have been various case laws that have come up on this point, many of which have been spearheaded by ISRA, couple before the Bombay High Court, many before the Delhi High Court, and they have been very successful in obtaining the due credit that goes to musicians even after the song recording is over. Even after they probably would have considered their song to be a dead mouse and would have thought, okay, I've sung the song, that's it, received the remuneration, no more value for it. But even after that, due to their efforts and due to the ample and exact interpretation of the provisions under the Copyright Act in such a way as to benefit the performers, the singers now enjoy royalty to continued live performances of their work, be it whatever venue. There is also an amount of debate in the court under various judgments as to what constitutes a live performance and what does not. But then most of it has been set to rest by the courts, and the courts have very clearly said that musicians are entitled to continuing royalties. Now, there are certain ambiguities in this. There are ambiguities as to how exactly the division of royalties takes place once the corpus reaches ISRA. There are also certain ambiguities as to what happens regarding the payables of royalties to a deceased singer. How exactly is it divided among his family members? All those are further questions that will be subject to jurisprudential analysis, and all of which is remains to be decided and freezed upon by organizations like ISRA, which work for the rights of performers. Other than that, there are so many issues that I face day to day in my practice regarding online platforms and intermediary liabilities. One of the issues that we see nowadays is the fact where influencers come in to promote a company's brand, and the company ends up paying the price for any violation or any infringement that the influencer accidentally ends up doing. For example, if Nykaa engages a couple of influencers who promote Nykaa brands, and in the process of which they have music playing in the background, which music they have not obtained the rights for that particular broadcast. A notice comes to the company saying that, see here, you have played our music without our permission. The company is clueless, and then the company goes back, looks at the video and understands, okay, the influencer has used these particular tracks in its video promoting us. So that is an indirect problem that many of the companies are facing now when we have this increasing trend of influencers promoting the brand. There are also various other issues regarding intermediary liability, but I think you will be coming back to us. Yes, thank you, Sanjay.
Very pertinent points raised by Lakshmi. And let me just respond to it because I'm the one who is the creator of it all. Just also respond to it just for the information of everyone. Yes, you see the problem with our country and the people living in this country is that we all think music is our birthright. And birthright without paying. म्यूजिक बजाना हमारा जन्म सिद्ध अधिकार है, मगर उसका पैसा नहीं देंगे, ये हम में सब में खून में है, which is wrong. None of us, including we, all sitting here, as well as we all working in this world and in our country, all of the budding lawyers, we do pro bono things, but definitely we also have to earn. We are here, we are studying law to earn money. Similarly, artist also does his performance to earn his money. How can somebody use that particular creation free? And that's exactly what I had taken up in 1990. It took me 22 long years to really get the law amended through the parliament. Especially, I am so grateful to the parliament because it happened with both the houses of parliament according an approval that the artists should start getting royalties the way it happens everywhere, from the commercial exploitation of his or her performance. And that's where ISRA, the Indian Singers' Rights Association, now ISAMRA, was formed. And that's where we started off to start collecting royalties for artists. As per our law, as you know, that the distribution of that royalty has to take place as per the distribution norms laid by the members themselves. And the members have now devised a whole strategy, or rather a whole distribution plan as such, or the distribution scheme as it is called legally. And the distribution scheme is very clear. It is not that we are a Rotary Club of India or an INBA here, that we give the monies equally to everyone. No. It goes as per the logs. So if your person's music or the performance is being played in public and it is in the log, it gets paid.